Right. Okay. So let's get on to this. This is a really interesting subject. I say interesting. I use that word with a pinch of salt. It's actually not very, but it does affect a lot of people, and it affects our marketing. It affects pretty much every single marketeer. Well, no, not every marketeer. Every business within the UK at the moment to some degree. And I'm sure that a lot of you will have been receiving from your vendors these emails over the last few weeks saying, you now need to do this, you now need to do this. And before we do these things, we need to understand what the heck's gone on, what was it that was there in the first place, and how do these things now affect me? So I never just sign something, unless I'm buying a mobile phone. I just assume that it's all going to be good and I sign it willy-nilly. And in fact, actually, I sign quite a lot of things like that thinking about it. But the point is, should we just sign it? What is it? How does it affect us? And is it the right thing for us to do? So we pulled together this webinar. Philip, just before I get into Philip, actually, I'm Adam Oldfield. I'm the Managing Director of Force 24. We've been running for 10 years. We're a UK-based, which is the important part, marketing automation platform. We support over 4,000 marketeers in the UK right now. We have one of the best products at one of the strongest price points on the market at the moment. We're growing, probably one of the fastest on the market at the moment as well. Very, very big plans over the next 12 months, and it's a really interesting time for us. Philip, what I would like to do, would you mind introducing yourself as to why you are the man sat opposite me in this chat?
Well, among many other things, I'm the data protection officer for Force 24. I have a legal background. I'm a GDPR practitioner. And perhaps more importantly than all those things, I act as a data protection officer for a number of organisations, including companies outside the United Kingdom. So this issue is at the very heart of a very important debate.
Okay, you're the right man for the job is the point. And interestingly, fun fact, Philip was my first ever employer right out of school. So when I was 16, I was working part-time during my A-levels, I went to work with Philip. So that's how I met Philip many years ago. And it's come back to haunt me 30 years, no, not quite 30 years later, but quite a lot of years later. Okay, so let's get into this. So Philip, you gave me some really interesting facts about how the Data Protection Act actually came about and what that was. And do you mind just giving that to the guys now? Because I think this is
Yeah, sure. So I think what's at the heart of this whole debate is the protection of personal data. So we in the United Kingdom sort of didn't get occupied during the Second World War, but most of Europe did. And as a result of that, in 1945, English lawyers got together and they said that they must uphold fundamental human rights. And that was resulted in the first 8 clauses of the European Convention of Human Rights, which were actually drafted by English lawyers. And Article 8, the right to privacy, is basically where data protection comes from. In America, they never had any of these issues. So there is a different way that the States look at things to the way Europeans and UK subjects look at data.
That's interesting, Philip. You know, I'm a big conspiracy theory guy, right? And we'll come on to this later on. But what you're essentially saying there is that the war in Europe was the initial instigator of the Data Protection Act, of what became the Data Protection Act.
So fundamentally, yes, fundamentally, because there was a right to privacy, a right to family life, and all these things. And English lawyers saw the need to actually enshrine in law, and that was how the European Convention of Human Rights came about. And data protection is simply an extension of that.
So that's interesting. So isn't it funny how war manages to change legislation and pandemics and things like that? Insignificant things.
Yeah, absolutely.
Let's come on to that. So Philip, just could you give us a bit of a background as to what Privacy Shield was, what the forerunners were, why do we have it, and then we can go from there.
So America's very, very different. So just to explain to the audience, so the Privacy Shield is there purely to protect European data into America. So we don't have privacy shields elsewhere in the world, just one with America. America's an important place to trade. And there is no data protection legislation in the States, with the exception of the state of California. So in the United Kingdom, we have what's called the Information Commissioner's Office. That's replicated throughout Europe, and an organization within each country and Switzerland and elsewhere is responsible for protecting personal data. In America, no such thing exists. So the Privacy Shield, as such, which is a self-certifying piece of paper that a company in America signs up to, and it comes with binding arbitration, which will be upheld by the courts if necessary, is actually signed and the documents produced by the Department of Commerce, and in some cases, the Department of Transport. So if you were doing that in the UK, you do it through the ICO. In the States, that doesn't exist. So there's a fundamental difference in terms of how data's there. So the European Union has ruled, Adam, just to finish, that it's not safe to send data off to the States without protection safeguards being put in place.
That's interesting. So you said the Department of Trade and Industry. You also mentioned before on a previous chat, there was also the Department of Transport was involved in this as well. And,
yep,
and
absolutely.
So imagine if legislation, government legislation in the UK was being developed. I mean, I know the Chamber of Commerce lobby for legislation, but if they were the governing body for legislation, I wonder where the focus would be. You know, this is the Department of Trade. So what's their job? To get trade working, isn't it? So,
absolutely.
So what's the focus? So when you think about it, guys, it's fairly sort of obvious that it's not going to potentially stand up to the scrutiny that it needed to do. So, okay. So what, Safe Harbor. So 2016, there was Safe Harbor. What happened there?
Yeah. So a guy called Max Schrimps, who's a data protection champion, is an Austrian, took on Facebook, and it's called the Schrimps Case 1. And basically, he argues that Facebook had been sharing data with federal authorities, and the European Court of Justice ruled that actually he had a good case, and they struck down the Safe Harbor Agreement. The European Union was left then, or the Commission, in a very difficult position. It wanted to continue trading with the States, but the States doesn't meet something called adequacy, and we'll come back to that in a few minutes. So as a consequence of that, they then brought out the Privacy Shield, and that came with extra things, not just binding arbitration, but legally enforced arbitration as well. The problem is, Max has now taken Facebook to court in Ireland, and he won that case for Facebook sharing and breaching data privacy stuff. That's then gone to the European Court of Justice. It was heard last month, and the European Court of Justice did two things. The first thing, which is probably why you're on this webinar, it ruled that it basically didn't provide safeguards, and it struck it down. It said it's no longer safe, but it's also said that even with other safeguards in place, the sharing of Facebook's data with America would be inadequate.
Okay, that's interesting. Do you think, I mean, I'm a conspiracy guy, definitely a conspiracy guy. Do you think that the EU has got his bee in his bonnet about the USA, or do you believe that there is that the ECJ, European Court of Justice, has got nothing to do with political background? It is just about the hard, cold facts of the data privacy laws? Or is there please give me some conspiracy meat here?
Well, I think there's two or three strands going on here. First of all, there's an instinct in terms of the European Union towards regulation. In the States, there's a sense that they want less regulation unless you just happen to be trading with China. And then you've got a second strand going on there, which is trade. And it's fair to say that America, and currently the current president, has a bee in his bonnet about the importation of cars, Mercedes cars, for example, and he's slapped a tariff on those. So you've got that going on, and then you've got an argument saying that the Commission and other people may well be pressurizing the judges. But ultimately, fundamentally, there is an imbalance in terms of data sharing. So you've got a big clampdown through various Patriots Act and various other things going on in the States, allowing federal authorities access to absolutely everything. And you've got more data subjects' rights coming out in Europe. So the two are never going to match together properly. It's a mismatched couple.
Okay, so let's move on. Let's talk about explaining the lawful way of transferring the data outside the UK at the moment. But before we do, let's build a real case example, okay? So let's pretend we are, I said Bob the Builder, but you said Box Builders. Okay, let's go with Box Builders. We are a company called Box Builders, and we have 1,000 customers throughout the UK. Now, we use, let's not pick on MailChimp, but let's pick on MailChimp. And we send our email out through MailChimp, who we know are based somewhere in North America. I guess. I don't actually know where they are, but let's say it's North America.
Atlanta.
Atlanta, perfect. Okay. So historically, my safe, legitimate, legal framework for sending that EU citizen data out to Atlanta was Privacy Shield. That's now gone. So Philip, what is the new answer? What came about?
Okay, so the Privacy Shield was fantastic. I signed one. You sign in front of your attorney, and you say that you'll uphold data subjects' rights, and it goes to binding arbitration, and it's legally enforceable. Great. The problem is now that's not there. So it would mean that the equivalent of Force 24, based in America, would have to sign. There's two ways of doing it. So something called standard contract clauses. This is a lengthy document, roughly around 13 pages, and each party signs up to a whole set of clauses. It's very inflexible, but it is a legally binding document, and it basically allows the courts to scrutinize. So that's one way of doing it. The problem with it is that you've got to sign it up for every customer. So if you're in America, Atlanta, and you've got, say, 10,000 customers on your books or clients, you'll have to sign it individually with each client. There's no blanket protection. But secondly, allied to that, having signed that standard set of standard contract clauses, you've then got to go back to your UK. If you're based in the UK as Box Builders or whatever, you've then got to go back to your data subjects and say, we've signed this. We have now amended our privacy policy. This is the change. We are sharing your data with America, and this is the company we're sharing it with. So it is not an easy process.
There, right?
Sorry, Adam?
This is where I've got the right to say, no, I'm not happy with that. Right?
Absolutely. Absolutely.
So essentially, the big repermissioning project that we all embarked upon in 2016 pre-GDPR, in the run-up to GDPR, and the actual instigation of GDPR in May, was it 2018?
2018, May. Yeah.
It seems like 5 minutes ago. Anyway,
yeah.
that what we're saying here is that permissioning that you got, if you are using North American platforms, may not now be adequate. Not necessarily are you opted in or opted out, but you now need to go back to those data subjects and say, hey, guys, just so you know, Privacy Shield is gone. We're now storing your data in an environment that is not protected by a EU sanctioned framework. Instead, we've got a contract with somebody in North America, MailChimp, and they say it's cool. Are you cool? That's essentially what we're saying is what you've got to do. Is that right?
I think it's more than that. I think you've first of all got to put in your contract with the likes of MailChimp. Secondly, you must have a legally binding processing agreement in place. Thirdly, you have to tell your data subjects and effectively seek a repositioning with them and to tell them that you're sharing that data there. And it's up to them if they to withdraw their consent to you processing the data.
So if, let's pretend, I had, right from 2015, had the foresight and said in my privacy policy, by the way, when you do give us your data, I'm going to be saving it, I'm going to be sending it, specifically, I'm going to be sending it to North America. That would have been adequate, but the likelihood is nobody did that. And very few people have got evidence of being able to say that that's what we did. Therefore, you don't have my permission to send my data outside of the EU. I'm going to get mad. ICO gets involved, and we're in trouble. But before we go there, let's come back, and so let's just talk about very quickly the global situation. So as we understand it, that there is a basis, there is a decision that the EU has made as to the adequacy of the country. So do you want to specifically talk about countries and the adequacy and what they're looking for to make that a reasonable place?
So the European Commission has published a list, which it continues to regularly review, of countries that meets adequacy. Adequacy, what's that? It means that they have laws in place to protect data subjects, which are legally enforceable, and the data subjects can take people to court. So the United Kingdom, for example, people take the government to court for all sorts of reasons. Somebody's had the passport withdrawn, they have a right to challenge that in the courts. In many other countries, you can't do that. So certain countries have signed up and agreed to a legal framework with the European Commission. So it's interesting who signed up. So you, Adam, you may well say, I'm assuming Australia signed up. Australia doesn't meet adequacy.
Wow.
New Zealand meets adequacy. Argentina, I'm old enough, Adam, and like you, to remember a war we had not that long ago with Argentina, right? But Argentina meets adequacy. Uruguay meets adequacy. Israel meets adequacy, but lots of other countries outside what I call the EEA, the European Economic Area, which is bigger than the EU, as you all know, don't meet adequacy, and you cannot share data with them. And if you do, you're putting data subjects at risk. And the Commission, and at the moment this applies to the UK, because we don't sort of we're still in sync with the EU while the end of this year. You face consequences, and I'll talk about those consequences, but these are real serious fines.
So is there any fundamental reason? I know you mentioned it's about having an equivalent of the ICO. Is there anything else? I mean, most notably, the USA is not in that list. And by the way, we will publish the list, the URL, by the way, where you can find a list that the EU has sanctioned as being safe countries for storing data. You won't be surprised, Somalia is not on there, Shane, and neither is North America. But that's interesting that the US didn't meet adequacy laws. So do you want to specifically drill into what the USA? I know we've talked about you know, the general principle, but it was interesting in our last chat we were talking about how each state has the ability to. Do you want to just elaborate a little bit more?
Yeah, I mean, we need to understand and remind ourselves, we talk about the United States, and there's lots of stuff banged about. So North America, we would include Canada within there. Obviously, Canada does meet adequacy, but the United States doesn't meet the adequacy test. The problem is with the American system, it's a federal country, so the federal part of the government are responsible for certain things, tax and trade, but the states are responsible for citizens. So obviously you've got a state governor and various other functions going on there. So one state, which is California, does have data protection laws, and quite robust ones in some respect. Doesn't meet them to a standard that the EU would approve of, but nevertheless has them. But the rest of the other states don't have. So it's the problem for America with this, trying to solve it. There's no quick fix for them, because if the federal government could be responsible for data protection, could pull all that in and put it in place. But the federal government's responsible for defense, for rooting out terrorists, declaring war and all those things, and protecting civilians. Data protection is not on its list.
You know, it's funny because two things really. Arnold Schwarzenegger, obviously, famously had a stint as the governor of California for a while, and actually one of his agendas was data security. True fact. Being an Austrian citizen. The other thing is, again, I love a conspiracy. Absolutely love it. You know, the talk of the Patriot Act post 9/11. You know, generally, you know, post 9/11 for whatever. Talk about 9/11 on a different chat, but the point is, following 9/11, the breakdown in data privacy rules that were held within the Constitution at that time, which Clinton was trying to push out, were being pushed back by Congress. Post 2001 9/11, basically they just eroded pretty much all data privacy laws, and that's the Patriot Act, right? That was basically any data stored on North American shores or USA, within the USA, is the North American government has access to, or state officials, as you mentioned earlier on. Is that right?
Absolutely, and in some cases they can put the fingers on data that's held elsewhere as well. So there is a duty, patriotic duty for American companies to share data. So you're getting into the Chinese scenario with Huawei and the problems there, and people claiming that they have a duty, and the Americans have claimed they have a duty to share it with the Chinese state. America's no different.
You know, we've not actually mentioned China, but I don't actually.
Well, China we would accept. You know, it's a communist state, doesn't and it's not a democracy as we would recognise in the West. It's not doesn't meet the standards of adequacy. We would understand that, but in some respects, the states is not much different.
So I've got a question here, Simon Flaxman. Thank you very much. So if Canada meets adequacy, does that mean that customers wouldn't need to be made aware of their data being stored there? So if we're using, let's pretend we're box builders and we've got a, let's say an ESP, an email service provider, and they're based solely in Canada. They don't have any links to North America. They're a Canadian business. Technically, the data has to fly through North America. I don't know if that makes any difference or not, but anyway, it goes Canada. Do I still need to make my data subjects aware? They meet adequacy.
Yes, but you would do so through your privacy policy. If you're storing any data outside the EEA, this European Economic Area, you need to list on your privacy policy where that data is stored. And people apply this in different ways. Some people actually list their suppliers down there and put where they're based, and some people just put a broad description and the country involved. But you do need to have that in your privacy policy. Okay,
so what you're saying is that's just smart. You should be doing that. And if you are using a Canadian business to store data for whatever reason, that you, even though it meets adequacy, and technically the EU has given me a framework to say you're good, I still should, within my privacy policy, state that I do use a Canadian business. And is that essentially what we're saying?
Absolutely, yes.
Brilliant. Okay, awesome. So really, really interesting stuff. So we've also spoken about the governing bodies, the right to recourse. Basically, what we're saying is in order for an organization, a country to meet adequacy, there should be a governing body and a set of rules that protect the data. Is it an EU policy to say that every state within member state of the EU should have an equivalent of the ICO?
So it's mandatory. It's more than should. So it's mandatory, and then there is actually a European data body that sits above all of those organisations and actually lays down guidance, and you can actually challenge. So if you, and at the moment in the UK as well, so if you were concerned about the Information Commissioner's Office, how it had handled your data, you can actually complain to the European Data Board about the processing of your data, and they can actually rule that the ICO has handled it wrongly in some cases.
Okay, thank you very much. So Simon's then come back and says Shopify is based in Canada. Now, interesting point here. Now, I don't know about the legal structure of Shopify. I don't know. The thing to check would be, and this is what I recall from the Safe Harbor debate many years ago, was the fact that even though the data is hosted on a server in Canada, that itself is not the be all and end all. So for example, if I have a support function in North America, and that support function in North America is responsible for that platform based in Canada or the EU or wherever it is, technically, in order for me to resolve and debug issues that you have on your Shopify platform, then you are exposing your data to North America again. So the problem comes back to haunt you. I know there's been a lot of noise about, but you know, we've got a server in the EU. Yeah, but that's fine. Is your entire support function located within the EU? Is the organization saying that at no point the data is exposed to the North American shores, in which case support cannot be vended from those locations? Is that right, Philip? Am I right in saying that as well?
Yes, broadly you are, but I think we just need to just refresh. Canada as basically meets adequacy. The Commission recognises it's a safe place to send data. The problem that you've got, as you've touched on, is if Shopify, as an example, then have offices in the States for development work or whatever, that means potentially that data that's in Canada is getting shared with the United States. That doesn't meet adequacy, and that's the fundamental problem there.
Okay, cool. Chris Greenbank, you've got a really good question. Do you mind? We'll park it until we get to it, because I think it's a really, really interesting question. And then and Helen as well. Let's move on a couple of steps, and then I'll pull back those questions in just a second. So one thing I want to say, there's obviously a reason why Force 24 is sat here talking to you guys, hopefully, and Philip as well. So we are a UK marketing automation platform. So this is obviously really good news for us, and that's sort of putting our cards blatantly on the table. And that is our entire infrastructure is based within the UK. So as Philip will tell us in a moment, a very interesting revelation about the GDPR post-Brexit, and I'd like to dig into that in a moment. What you do right now, as much UK-centric as you can be, protects you. Unless you start referencing across the privacy policies, all sorts of locations across the world, the current trend is to globalization. And the trend is to say that we'll have data going out to India for support of that description. We'll have data going out to Thailand for support of this description, data going out to North America for support of this description. Whereas Force 24 is a UK-based marketing automation platform. We've got 4,000 marketeers. Our servers are located within the M25. Our support function is located within Leeds. And we give free training and support for life as well, by the way, as it says up here somewhere. And the point that we're making there is, look, the one safe answer, there's lots of ways that you can tweak these model clauses, and we'll come on to that in a second. There's lots of ways you can do this, but there's an even easier way. Keep it in the UK. Support British businesses. We support you, you support us, and that's how it works. Granted, we're not saying work with an inferior product, but 4,000 marketeers and a 98% client retention rate says there's something there to have a look at. So that's my little two-penneth done and dusted. So let's get back to the point. I can't rely on Privacy Shield anymore. We know that, we recognize that. There was one interesting point, though, which was made earlier on, which is self-certification. A lot of what's going on now, even what the new standard clauses, these are self-certified. And let's just, before I hand over to Philip, self-certification means, as we've already said, we download a set of things and say, yeah, I do that, and I sign it in front of my attorney. That's it. I don't actually have to do anything. I just say that I'm doing it. So self-certification itself is a little bit scary if you think about it. I mean, good luck against MailChimp in something like this. Okay, so Philip, do you have anything that you want to add about that before we get on to the what's now? How can you do this now?
I think there's a few things. The first thing is, if you're doing self-certification, can you actually enforce it at the end? So we're not going to see anybody extradited from America to the United Kingdom to stand trial for breaching data privacy laws in the same way, for example, when the guy had shall we say, a misunderstanding who worked for Morrison's and decided to upload their entire list of ex-employees and current employees to the internet. He was put on trial for breaching the then Data Protection Act, and was sentenced to a period of detention, shall we say, in Armley Jail in Leeds, if anybody knows where that is. But also, in addition to, the data subjects had a right to bring an action against Morrison's, a civil action incidentally, claiming the sort of breach of their privacy. That has actually progressed from the High Court. It's gone to the Court of Appeal. At the moment, the Court of Appeal has turned down a compensation claim, but that's likely to go to the Supreme Court, and that's cost Morrison's a lot of money to fight and develop through. You don't have that level of protection in the States. So, the risk, it's meant to be binding arbitration, it's meant to be legally enforceable, but it's quite difficult as a European subject or a UK subject enforcing things in American courts.
Yeah, and that instance of Morrison's, actually, that's really reassuring, isn't it? Somebody did something wrong and there was a framework in place that he ended up in jail. So there was both the commercial and the civil action brought against both Morrison's and the individual. And that's the reassuring part. That wouldn't have been the case in North America. By the way, James, Heath, Monica, and Ian, I see you've got questions in there, and it's okay, I'm not ignoring you. We're going to come on, we'll answer all those questions in just a moment. So let's talk about the standard clauses. So let's talk about where we are with what now is the case. So we know the ECJ has ruled out Privacy Shield. We know that's not the case. We know that Facebook, we know that eBay, we know that MailChimp, we know that all these, they're not going to turn the back on the EU. That's never going to happen. But do we know what is now? How does it work now?
So the only way you can share data with the states at the moment is two things. If you have a head office, for example, in America, and you want to share the HR records, which is not unreasonable, from your UK subsidiary, for example, you have to put in place something called binding corporate rules. And those are binding documents which gives the data subject certain rights. And that is for intercorporation sharing, so business to business sharing, which are part of the same group, same chain, or same division. If you're not part of that, the only way that you can share data is through standard contract clauses. And this 13-page document, I think it's about 30 pages. You literally sets out what you can do, what you can't do. Both parties sign up to it. And there's no opportunity whatsoever to change that. It's inflexible. And that is the fundamental problem, because in business, we all know everybody goes, well, but I'd like to put that in there. Or, but what about this bit of protection? You can't do that with standard contract clauses. You're locked into what they say, and they're drawn up by the European Commission. Nothing wrong with them, but they're dry, legalistic, and for most people, it's kind of over the top.
That's interesting. So what we're saying is that MailChimp, HubSpot, whoever it is, will say to me at this point, you now need to sign our standard clauses. You need to sign these. You've got no option here. You are up against the fence. I have to sign this. And there is no point reading it, is what you're saying, because there is nothing you can do to change those clauses. They are just what they are. And I can imagine that in order for, if the Department of Trade and Industry in North America are responsible for this in any way, and I get that the European Court of Justice are the ones that are sort of enforcing it, but that's going to be largely lobbied and led by North America saying that's not acceptable, that's acceptable. They're going to have put the favour. Who's it going to be on? Is it going to be on you, Mr. Customer, based in the UK, or is it going to be on the UK, on the USA business in which they represent? So you're going to get a contract, and this is the bit that I don't like, that's not been written by you, that can't be changed by you, that is largely going to be created by the ECJ, who are interested in your consumers, not you, and the Department of Trade and Industry in North America, who are interested in the American platform, not you. So where's your representation in this, Philip? And am I wrong in saying that, or is that?
No, you're absolutely right. So I've actually had a letter. So it's the Department of Commerce in the main, Adam, and the Department of Commerce has put a letter out, and I have a copy of that letter, and it says basically the Privacy Shield has been sort of declined by the European Court of Justice. Just continue trading as normal. So there's no invitation there to fill in standard contract clauses or any other safeguards, just continue trading. The point here, Adam, is, and this is the key thing I want to tease out this morning, is that if you're the data controller, i.e. the person who has the data in the UK or the European Union, you are responsible for that data. You can't absolve yourself by passing it to someone else and signing documentation. You're still legally responsible. And if you send it to the States, and it gets screwed up in the States, even if you've got documentation in place, you're still accountable for it. And you're the person who'll get fined, because you're the person who's entrusted with EU personal data, not the company in America. They're working on, hopefully, a processing agreement with you. But effectively, if it goes wrong, you're on your own.
Yeah, absolutely, absolutely. And there's an interesting point. We were chatting earlier on before, obviously, this webinar, and we were talking about the Cambridge Analytica Facebook thingy, weren't we? And we were talking about how this has actually been used, slightly off topic now. We'll get into the questions in a moment, but how this data, Facebook essentially sold the data that should not have ever been sold of UK citizens to support the Leave campaign for the EU. And there was a documentary, obviously Netflix, all good documentaries come from Netflix, obviously got to be true because it's from Netflix. But anyway, the point is that it was a really interesting insight as to how that data was used. And we were talking about it before, Philip, because what I found particularly interesting was the fact that Cambridge Analytica, who are now out of business, originally started business as a military communications specialist. Okay, so they were classified by the military as being a weapon. And their aim of their weapon was to stabilize the local inhabitants of somewhere that they were going into. So they wanted, if they were going to invade a particular location, whatever, or going to move the troops in a certain division of Iraq or whatever, what they'd do is they'd send Cambridge Analytica in first to win the hearts and minds of the inhabitants, to mitigate the radicalization of the individuals, to reduce the number of RPGs thrown and the gunshots at the tanks. So the interesting was, there was this, In the Great Hack, the movie was called, the documentary, I'll give it some credit. The documentary, they interviewed the sales director of Cambridge Analytica, or the ex-sales director of Cambridge Analytica. And the question that the interviewer put to the sales director was, so, okay, you work for the military, and you have been classified by the military as a weapon against whatever, and you work for political organizations influencing individuals on the ground to vote a certain way. So one's a weapon and one's a political tool. What's the difference between the version of your business which is classed as a weapon and what you do on the ground? And the sales director said, nothing. It's the same thing. We do the same thing. So what's interesting here is when we sort of are quite flippant about data, and we're flippant about why the European Court of Justice threw this out, I want you to just think about that. That's why. Because in the wrong hands, that data is extremely powerful. Whether you believe in Brexit or not, the fact of the matter is, it was largely led by skewed facts, and actually mostly by propaganda put out on Facebook by people that you've never even heard of before. Right or wrong, that was how the war was won. So really, really interesting point there. Philip, before we move into questions and answers, do you think there's anything that we've missed? It feels like we've been through a lot of oh, I tell you what we haven't really talked about is, what's the worst that can happen?
Yeah, I was going to come on to that. So the European Union has ruled that the worst possible thing is the transfer of data elsewhere in the world without adequate protection. And they can fine up to 4% of worldwide turnover. Now, we're leaving the EU at the end of this year. Well, we have left, but we're still in sync with European law. But the United Kingdom government will continue with GDPR post-Brexit. We'll have a version. I'll talk more about that in a minute. But the point being is, your business can be fined 4% of worldwide turnover. And if you think that's not going to happen, ask British Airways or BA. They had problems with their data and being accessed, and I think they were fined £252 million. I'm sure they'd like that money back now.
Ouchie, yeah, I bet they would. They're probably getting it back, in all fairness.
Possibly, yes, through furloughing.
Yeah, so just quickly then, let's talk about the GDPR then. So interestingly, I didn't know, I've not been paying attention, but the GDPR post-Brexit, there is a plan. I'm right?
There is indeed, yes. So GDPR is going to be taken into domestic law, i.e. UK law, English law, and it's going to be slightly renamed. So it's going to be GDPR, which is going to be a real mouthful, because at the moment, some of you will call it GDPR, some of you will call it the GDPR, which is probably more accurate, but this will be GB, Great British GDPR. Now, there's going to be some changes. So, and we always know when the United Kingdom incorporates things into domestic law, they always, shall we say, gold plate everything. So anticipate some more data protection changes coming along later this year. And I'm happy to talk to you about that through Force 24 in terms of how we can potentially help you. But there are changes on the horizon. Now, the Data Protection Act 2018, interestingly, will stay in place. There was a talk of that changing to Data Protection Act 2020 and incorporating everything, but that's going to remain separately. And that covers policing and security and things not covered by GDPR. Yeah,
okay. So let's now move on to questions. One question, so I'm going to answer this one from Paul Berwin, from Berwin's Digital. So this is a man that Paul Berwin is obviously a man that knows what he's talking about. So let's have a listen to what he's saying. The ICO is saying if you're operating under Privacy Shield, you should continue as you are, which precludes them from enforcing any breaches. Interesting point. But this suggests that you can't change the business that you're doing business with. They would, because you would then be going into an unprotected environment. So Paul, firstly, that's an interesting point, but it would only really apply if you change the business that you were doing business with to another business in a territory that didn't meet that requirement. I believe I'm correct in saying. I think your point is very valid. The ICO are saying, look, don't start getting scared. I think we're gonna give a little bit of time to transition here. But then again, the law is the law, and how long can you hold on to a position that says what it says? And when you're the point here isn't actually a legal debate, in my opinion. It's, do you want this continual trauma in your life of dealing with these North American businesses when you have a choice? If you didn't have a choice, I'd totally understand it, but you have a choice. And if you continue to make that choice, you have to continue to evolve with the legal framework that it brings. So Paul, I don't know whether there's any more specifics that I know exactly who you are, so I understand that it's coming from an interesting place. But if there's anything that you want to add or contribute to, I'd be more than happy to take it as any direction that you've got to give on this point. So
can I just put a point in there, Adam? At the moment, because we're in sync with the EU while the end of the year, ultimately the European Data Protection Board could overrule the Information Commissioner's Office. And at the moment, the European Data Protection Board is just sitting on its hands, and that's why the ICO's come out with that answer, because there isn't really any other solution that can instantly come up with without disrupting data processing. But, and here's the but, the ICO may well find itself out of sync in a month's time.
Okay, interesting point. So, Helen, I'm just going to take first names because my eyesight is terrible and that looks like a really long word. So, Helen, Spark Post have data centers in the US. If they use them for email marketing, I'm only sending email addresses. How do I communicate with those data subjects via Privacy Shield? So, actually, just before we answer that one, Ian, you have actually asked a fairly similar question, which kind of dovetails in, which is, hi, how far do these issues affect business data about individuals, i.e. their work email address, their work phone number, their job title, their employer, etc. So Helen, what you're kind of saying there is, so firstly, let's answer Ian's, and then we'll answer yours. So Philip, how far does data that I hold as a business-to-business operator, box builders, they sell boxes to other businesses, I hold your data as the representative of your business, and I've got your name, I've got your first name, your last name, your work email address, and your work phone number. How does that work? Is that
okay? So that is all. The work email's a bit arbitrary, but the rest of it is all personal identifiable information. So somebody can put those two. You've got the full name there. You've got a telephone number for that individual, maybe a mobile number, or things like that. That is personal identifiable data, and you are sharing that outside the EEA, and you should not do that at the moment unless you've got standard contract clauses in place. Now, the email address depends. So my Force24 email address is philip.allett@force24.co.uk. If you want to send me an email afterwards. The point is that gives my full name, and therefore that's personal identifiable information as well.
Yeah, okay. So Ian, I hope that answers your question. I think this was obviously when the GDPR came in, this whole debate kicked off as well. What is PII? And I think it's also when you can bind PII, so several data points together on a single record, make it, whereas with an email address, if it was just info@business name, no PII, until you say that you can contact Philip Allett at that email address, which still is a bit grey because you've got that info at, but the point is, it's how you combine it, and the email address does combine the lot, so it's risky. So there, Helen is talking about Spark Post. Okay, so Spark Post are a great example of this, and so Philip, if I may, because I do have some technical information around the way that Spark Post operate. So Spark Post operate, but they send around about, I think it's 37% of the global email. So every email that goes commercially on this planet, 37% of it emanates from within a Spark Post environment. MailChimp use Spark Post. We use Spark Post. Loads and loads of platforms across the world use Spark Post. But what's the difference? So when we execute, if you execute directly through a Spark Post interface, you are uploading your data into their data centers, which may or may not be based in the US, may be based in Europe, which they do have a European server. But that data then is then accessible from North America. So in theory, it would have an issue if there was a support requirement using their interfaces. Now, when somebody like ourselves and one of our ESP partners is SparkPost, use it, we do different. So what we do is we hold the data here. We have a UK instance of SparkPost, and we route that record, which lives within that system for a split second. So it would be very unlucky for a data subject in order to receive that and being watched from North America. So there's a slight difference. The data is transiting through a SparkPost server in the UK rather than residing permanently within their EU infrastructure, which is accessible through North American support channels, because all of their support is done through North America. How do you communicate with your data subject? Well, that's a good point. And as Paul Berwin's quite rightly said, is that ICO have said, you've got a bit of time. Don't, we're gonna come after you, but you know what? We recognise this is really fresh, and we recognise that businesses are going to have to adapt. But know that if you're using SparkPost, businesses like ours, businesses like MailChimp, well, actually MailChimp's based over there. Well, we can use SparkPost for you in a secure environment. So that's a very interesting point, Helen. Obviously, I'm here to sell our stuff. You know that, right? You know, this is a commercial webinar. There's no secrets here. But Philip, is there anything that you want to add? Because I feel like I've just totally given my uneducated view on.
No, I think it's a fair summary. What the point you've made. I think the key point is that you're processing through a UK. Their UK server, so that is different. You're not shipping the whole lot off to the States to be processed.
And just to be very, very clear, that it is actually just what they call an MTA, and an MTA isn't there. So you don't build emails in it. An MTA is just their back end infrastructure that goes zip through like that, and it's UK server. So it's in theory, we're as good as you can possibly get with this. We also have our own UK infrastructure, our own UK Force 24 infrastructure for businesses that are very, very specific, and they say, no, you can't use that. We have our own MTA environment where we have, essentially, it is all what they call Power MTA infrastructure. So our infrastructure software on our cloud in London running our MTAs. So we've got options to cover it off if a business was particularly.
Yeah, I think the other point is, Adam, I would make the point, having somebody who's used things like MailChimp, you upload all your data to MailChimp in the United States. So you give them the name, the address, sometimes the telephone number, and you can effectively use that as your database. And of course, some people do.
Yes. Okay, let's crack through some more questions. Monica, who needs the contract? ? Platform with production company, or is it the client for the events? Oh, okay, so that's the wrong way around. We're using the American event platform to stream events from a UK-based client, for a UK-based client. Platform had the privacy shield, and our client needed the platform to be GDPR compliant. But now I'm not sure what to do. Where do I go from here to be GDPR compliant? That's an interesting one, because I suppose you're holding events like this, I guess, and each of you know Zoom. You've accepted that, you've not signed up to Zoom from Force 24. You've downloaded Zoom and you've accepted Zoom. So I see that as being slightly different. Wouldn't you say, Philip?
Well, I think to some extent you're taking the risk, but what's the risk? You've got to calculate what the risk factor is. So there's not a straightforward answer to this. So if you choose to download Zoom and you know you've downloaded Zoom and you know it's coming from America, in many respects, you know what the risk is involved. I think the difficulty is if you're processing data and people are not clear how you're processing that data and what platform you're using. So, I'd expect you to have obviously standard contract clauses in place with your American supplier, but I'd also expect that to be reflected in your privacy policy, but I'd also expect you to be upfront with it so people can at least make value decisions.
So what we're saying in your instance, Monica, is that it sounds like that if you are using that North American platform to hold data of EU citizens that have not said it's okay for you to, hold that data there, that's a problem. If you're using a UK platform to say, hey, by the way, guys, we're going to be holding a webinar or an event, and it's on Zoom, that feels like, as Philip's saying, you're sort of managing that risk because the Zoom process says, hey, you're about to download Zoom. Are you cool with us storing your data over here? And you as an individual then accept that liability. So it feels like the bit that you've got a question with is, how does the data get there in the first place? Do you upload it in there, or do they say, yeah, I'm okay to be a part of this, and then insert it? But if it's I think generally speaking, it's going to be a really smart play to speak to a solicitor and make sure that you you update your privacy policies, and you have in place with any of your American partners the model clauses, the standard model clauses.
Yeah, and these things Adam, we can help with for them.
Yes, absolutely, yes. The description of data processor. So this is James Heath. Thank you, James. Description of data processor seems broad. The recent ruling of the ECJ has made one of our Danish clients nervous that we will, as an English company, will somehow break the rules in January. Now, this is actually an interesting point, and somebody else mentioned this before, and I said, well, we'll talk about this in the moment. Yes, Chris Greenbank, and you were sort of saying the same question in reverse. So Danish client, as an English company, will somehow break the rules from January, given away it throws the UK adequacy into some doubt. So is the EU going to say that the UK does not meet adequacy? In which case, am I holding EU citizens in an EU environment at risk? So
can I just pick up on that, Adam?
Yeah.
So there's a few things here going on. So obviously people know there's Brexit talks in progress at the moment. Part of that is to make, because the UK clearly does meet adequacy, in my opinion, but I would say that, wouldn't I? But that's part of the Brexit discussion. So I'd be very, very surprised if the European Commission didn't rule later this year that we don't meet adequacy. I think they will rule that we do meet adequacy, because that's, again, all part of making the markets work effectively, and we clearly do all the things, and on some things we actually lead Europe on in terms of data protection. So I'd be pretty surprised, unless it was a political decision, that we didn't meet adequacy. But I agree, it has made some people nervous.
Absolutely. So that one is, I think, is a watch this space. It's one of those situations that you can't shed light on right now, but the very fact, as Philip said, that the UK was the forerunner back at the end of the Second World War of the Data Protection Act, and then the fact that we've been sort of a leading light in data protection over the years, unless there is some sort of significant political play, then that should just go over as a fairly simple matter of course. So let's have a look. So next one is JAG. My understanding that the BCR had to be approved by the local data authority. Philip, I don't know. So my understanding was that the BCR had to be approved by the local data authority. Do you mean?
So he means I think he means the Information Commissioner's Office. Yeah. And that is absolutely correct.
Yeah. Okay.
So that differentiates it from the standard contract clauses, which are obviously, as the name suggests, it's drawn up, you can't change. So for corporate, because it's designed for corporates, you can incorporate things in there. But if you do change it, so there is a standard template for this, but with the we'll start again, binding contract clauses, you can modify, change, but then you do need to get that signed off. So if you're in the UK, you need the ICO to sign it off.
Yeah, okay, perfect. Anthony, thank you very much. Anthony is a regular. No, Anthony, well done. So why isn't there more noise about this from our esteemed government? Bloody good point. But I think actually it's fair to say the government have got a fair amount on their plate right now.
Yeah.
Coming out the back of the pandemic and then moving into Brexit. The reality of it is, yeah, you're right. But I think as Paul Berwin's mentioned there, the fact that the ICO have stated that, look, let's not do anything too hasty. That's probably a political play from the government to say, listen, just chill out for a little bit while we just sort out.
I think it's even more than that. I suspect the ICO just haven't got enough staff to enforce it if they wanted to.
Yeah, probably. Very true. So, Ben Derrick, let me see. So, Ben, what you're saying we have a customer who has a head office in the US and an office in the EU. data financially from one system in the EU is being transferred to the other system in the US and vice versa. Our role is to create integrations as a software layer. Where does this leave us? Well, I think this plays into the hands of the standard contract clauses, does it not, Philip?
Binding contract regulations,
rules.
just to confuse things.
Yeah.
So you'd put a BCR because if the two companies are sharing data between them, then you put them in. But of course, if you're a third party that's totally separate from these two entities, you're quite right, Adam. Standard contract clauses.
Yeah. Okay. So Ben? I assume you're asking, are you at risk for facilitation of that data?
That's the question to ask.
If you are at risk and you are providing infrastructure, I would see as the defining point. If you're just providing a service as deployed into their environment, then I should imagine you're fairly hands off. But if you are in some way facilitating that transfer, you would probably be. But to be honest with you, I think we're dancing into the realms that sits way outside of my experience. And again, some of this is speculation because it only came about the other week. So hold our hands up. We're best guess on this. Anything that you want to add on that one, Philip?
No, not really. I think this is where we get into something I would do, which is called data mapping, and we'd actually look at where data flows, what the quality of the data is, what the risks are, what the intervals are. That needs mapping out as part of this process. Then you can then start looking at what safeguards you can put in place to protect it.
Okay, so I'm going to go to VAS real quickly because I saw the word HubSpot, and that's one of those burning keywords for me. Okay, so if you use HubSpot, what should be the actions with HubSpot and our clients in HubSpot? Now, I'm assuming there, Vas, you're a UK organization and you store either UK citizen data or EU citizen data within HubSpot over in the States. So, Philip, what should VAS be doing to answer that?
Okay, so there's two things with HubSpot. It could be it's been held on a server in Europe because they do have an Irish office as well. But let's assuming they're in the States, that's where your data is, or at least the States has access. So you're into standard contract clauses. You need to make your customers who you're communicating aware through your privacy policy. So that would mean updating your privacy policy or privacy notice or privacy statement. They're all the same thing. So it needs to say that you use HubSpot, where the data is stored. Obviously, you've got all your other good things in that privacy policy, such as how people contact your data protection officer, etc., etc. So you need to do that, but then you need to send that privacy policy out as an update to your customer base, saying, look, we've updated it. We do store certain things in the States. You just need to be transparent. If you're transparent, that's fine. If you're not transparent, that's where the problems arise, because GDPR requires us to be transparent in how we process personal data.
Or, Vas, move to Force 24.
Exactly.
There we go. I've said it now. So Paul Berwin's come back, and thank you for... I apologise. Thank you for the response there, Paul. Yeah, you're quite right. I'm not going to read it all out. It's all in the chat. So if you want to read this, but the sentiment is quite clear that there ought to be a massive commercial and national urgency into finding a way through this. And there will be, and I think that will come. I think it is just as Philip said, and we mentioned before, ICO simply don't have enough staff. The UK government right now have only got so much airtime in the ears of the general public, and right now it is maxed out on other matters such as Brexit and such as the pandemic. So I think for the UK government, there would be if they wanted us to look over there whilst they do something over there, they would say something about it right now, because that would mean it would take the heat off something else and whatever. So obviously the way that the national emergency comes in is when the government sees that it will allow them some time to focus on something in a different direction. But thank you for your contribution, Paul. It's been very useful. And Simon Flaxman, you mentioned, is there a time frame on this, or is this just a case that must be dealt with as soon as possible? But I'm going from Paul Berwin's suggestion here that they're saying don't rush into this. I would say that there isn't a time frame, but I would say that you should, in all instances, post the point in which this happened on the was it the 1st of the 8th or the 8th of the 8th?
About I think the 14th, wasn't it? I think.
Sorry, the 14th of no.
I think it was.
No, that's not happened yet. We're still only in August.
Yeah.
The way the American dates work is confusing anyway, but I think it was middle of July. I think the point is, this information came in on the middle of July. Has that necessarily hit the public? Well, I think I think it has hit the public now. And so it's sort of fairly safe to say that you must be on a path to rectify the solution. If you are not demonstrating that you are not on a path to rectify the solution, then I think that's a very difficult position to defend. But if you are on a path and you're resolving this, then I think that's fine. I don't know though, and then this is where you're going to have to speak to the ICO and get their specific take on what the timelines are.
So one thing we're waiting for, Adam, is that the European Commission hasn't yet responded. So the European Commission's gone away to respond. The one thing is the European Court of Justice trumps the Commission, so its rulings are binding, but the Commission have gone away to think about how best they can deal with it. I feel it's going to end up with a deadlock situation, and ultimately the court always trumps the Commission, but we're still in this situation where the Commission's looking at it, and I suspect that's part of the reason that the ICO has just held back a little bit before diving in there.
Okay, good. Well, thank you very much. And Lorraine, I think this is the final question. Okay, so Lorraine, if a vendor like Zoom or Apple uses SCCs, what else does the data controller have to do to make sure their data transfers are legal? So let's take Zoom and Apple out of the equation. Let's assume that is just generic US business. So if a vendor, like, using a vendor, they have SCCs with you, what else do you have to do to make the data transfer legal? I think we've talked about, we've got to notify the subjects.
Okay, so there's a few things there. So we've got that going on, but from the vendor's point of view, they need to be as GDPR compliant as they possibly can be. So, for example, in America, I sometimes do GDPR audits, which are quite nice work to do, although not always remotely. And what we'll do is we'll actually go through and see what they've done, because there's no reason why American vendors can't put in place data subjects' rights. And as a European subject or a UK subject, you've got certain rights: access your data, corrections, stop automated processing. These rights don't exist in America unless the Americans write them into privacy policies and things like that. So that's what those vendors can do, and to get as near compliant as they can be. But a lot of these companies are way off sync, and some of them, it's just over their heads. They just don't have the skill sets in-house to deal with it.
I've got really Tony Sutton, we signed up to Force24 in July, and we're also using MailChimp and SendGrid. Do we get a Force24 Privacy Shield discount when we increase our email allowance? Now that's quite funny. Yeah, well, do you know what? Maybe we'll look after you. Of course we will. The fact is, we at the moment have been running a discount on onboarding as a sort of COVID support. We've given an increased email allowance to our customers during COVID, so you can talk more. Yeah, thank you, Tony. The same could potentially apply for Privacy Shield, but we don't know yet. But we'll look after you. But right now, actually, the COVID discount actually on setup is still applicable. So anybody that is thinking about moving from a US, we are discounting the entry point to get into Force24. So that you either deal with a headache or you just let us deal with it, and because we're UK based, or whatever. But I mean, just makes life easier. But what I would say is, I think that's pretty much all of the questions. And if anybody's got any more that they'd like to answer, then Philip has very graciously offered his email out. Crazy man. but please, do get in touch with us. Our website is loaded with lots of different ways in which you can talk to us. If you want to come and have a look around our platform, we offer demonstrations with product experts, and we are all about making it fun. Our product demos are not boring, they're informative, and they're all centered around you. I don't want people to feel that when they come and have a product demo with Force 24 that they are sat to an hour of boringness. It isn't. It's about 45 minutes, and everything is about excitement, no PowerPoint at any point, and it's all about delivering these things that are going to help you move forward. So as a business, we're really trying to get behind you as a marketeer. So if you do want to go on our website, have a look round, and then please come and book in to come and see us. So, Philip, is there anything you want to say as a final sign?
The ruling actually, Adam, was on the 7th of July, not the 14th. Yeah.
Perfect. So we'll send round this as a video to anybody that's wanted to, that's seen it, well, anybody that signed up, and you can watch it at any time. So thank you all very much for your time. Really enjoyed it, and we'll speak to you soon. Thank you very much.
Thank you, guys.
Bye-bye.